and thank you for joining us. My name is Kelly LeGrand Weiner, and I'm a partner at Scott Legal PC. Today, we're going to spend some time talking about the L-1 visa. A few housekeeping items before we get started. Some of you may know that the firm was founded on an E2 visa several years ago. Our founder is in the US on an E2 visa and has been on several different visas, including an F1, TN, B, and H1B. As such, we know what you're going through. The firm is a full service immigration law firm, and we offer immigration services in a number of different areas, including E2, E1, TN, L1, family immigration, national interest waivers, EB5, extraordinary ability visas, and more. We are Today I will be speaking, and as I mentioned, my name is Kelly LeGrand Weiner, and I'm a partner at the firm and have extensive experience processing L1 visas. If you have questions as we go through the presentation, please send them to the chat box, and we'll make time at the end for questions. And without further delay, let us get started on the webinar. All right, what is an L1 visa? The L1 visa is also called an intra-company transferee visa, and it is meant to allow companies outside the US that have a relationship with a company in the US to transfer employees. Let's talk about the basic L1 visa requirements. So first, there has to be a qualifying relationship between a company in the United States and a company abroad. This can be a parent, affiliate, branch, or subsidiary relationship, and there are very specific definitions in the regulations as to what the corporate relationship has to look like. So, sometimes, companies will say, oh, yes, we are affiliates. But ultimately, you do have to look at the regulations and see, does this qualify as an affiliate the way that the immigration regulations define it? So that's a very important first step. Both companies also have to be doing business. This is defined as regular, systematic, and continuous provision of goods or services by a qualifying organization and does not include the mere presence of an agent. If you are starting up a new office in the United States, though, this is permitted. We'll talk a little bit more about this later in the presentation. This is called a new office L1 application, and it means there's a few additional requirements, and the visa can only be granted for a year, as opposed to normally you can get it granted for at least 3 years. Looking at the other requirements, the employee applicant has to have worked for the company abroad for at least 1 year out of the past 3 years, and they must have worked in a managerial, executive, or specialized knowledge position at the company. So if somebody was, an executive assistant starting out and held that role for 6 months and then was promoted, to a specialist role for 6 months, that wouldn't work for an L1. They would need to work another 6 months to have a full year in that specialist role before they could be transferred to the United States. You also have to prove that the employee will hold an executive, managerial, or specialized knowledge role in the US. It doesn't have to be the same job, so they can be transferred to a different job in the US, but it does have to meet that requirement of manager, executive, or specialized knowledge. If you're going to apply for an L1A visa, this means you're applying for a job that in the US will be managerial or executive, and you can renew this for up to 7 years. Usually, you get an initial approval for 3 years if it's a regular L1 office petition. And then you can renew up to 7 years. If it's a new office, you get 1 year initially, and then you can renew up to 7 years. For an L1B, this is somebody who's coming to hold a specialized knowledge role in the United States, and you can renew that for up to 5 years maximum. What are the new office requirements? So, very common for companies to want to expand into the United States. Maybe they don't have an office yet, and they want to send, maybe an executive over or a manager to kind of start up the operations. So, for this type of case, a new office L1, this is applicable when the U.S. office has been doing business for less than a year. So even if you incorporated, if the business was dormant and kind of no active business or trade was happening, it would still be an L1, even if you were incorporated over a year ago. It would still be a new office case. If the US company is sending an employee to open a new office, as I mentioned, there are additional requirements that you have to meet, and these cases are scrutinized more closely. So it does mean a higher chance of a request for evidence for a new office case. For this new office petition, you have to prove that the company has secured sufficient physical premises to house the new office. So this means they will want to see pictures of the office, square footage, a residence, like a home that you say, I'm going to use a home office. That's not going to be sufficient. And generally, they do want to see that you have secured space, that is going to fit all the employees you're going to hire in year one, or if it's the type of company that requires warehouse space or manufacturing space, they will expect you've secured that space when you submit your application. Um, the employee has to have been an executive or manager for one continuous year out of the preceding, out of the 3 years preceding the petition. And the proposed employment has to involve managerial or executive authority over the new operation. You also have to include evidence that the intended operation is going to support that executive or managerial role within 1 year. By providing information about the scope of the office, the organizational structure, the financial goals, the size of the investment in the US. So does a foreign company have the ability to capitalize the US company and to, pay the executive or managerial employee and to start up the business in the US? They'll also want to see the organizational structure of the foreign company to see, is there support there to start up this new office? So especially if you're applying and there's kind of no employees hired in the US yet, they will want to see that there will be sufficient hiring over the course of the year such that the company can then support that executive or managerial role, that they'll have enough money to fund this, and also that there's a sufficient structure in the foreign company to support starting up this new office. If you're doing a new office petition and you're sending over a specialist an L-1B visa, it's a little bit different. There's slightly lesser requirements. So one, you still have to provide proof that you have secured sufficient physical premises. So that's always going to be important. And you have to demonstrate the petitioner has the financial ability to pay the employee and to commence doing business in the US. So when you're doing an L1A new office petition, which is much more common, you're going to have a few more things that you have to show, to demonstrate that, this will support this type of role. All right, let's talk about the definitions of, executive manager and specialized knowledge because it is very specific, and it's something the government focuses on a lot when deciding whether to approve an L1 petition. So for the executive capacity, this is somebody who directs the management of the organization or a major component or function, establishes goals and policies, exercises wide latitude and discretionary decision making, and receives only general supervision from high-level executives. Generally, to prove this, you're going to submit, pay stubs, and you're also going to need to submit detailed letters and possibly supplementary work product to prove that this person, does these types of executive activities. What you don't want to do is you don't want to submit a letter that says they direct the management of that just, exactly reiterates the language in the regulations. They do want specific context. They do want specific examples. When they say they direct the management of the organization, often this means they want to see, that the executive is directing high-level managers to do things within the organization. So you do need to get specific and kind of provide the context so that, the government feels satisfied that you're not just regurgitating the regulations to them. All right, let's talk about managerial capacity. So, for someone who's coming over as a manager, they manage an organization, department, subdivision, function, or component of the organization, supervises and controls the work of supervisory, professional, or managerial employees, or manages an essential function. So, this is an important thing you'll see later, down in this definition. They do indicate a first line supervisor is not considered to be acting in a managerial capacity, merely by virtue of the supervisory duties, unless the people they're supervising are professionals. And professionals are defined as people whose jobs require at least a bachelor's degree or higher. So somebody who is kind of very low down on kind of the company org chart, and maybe they are, supervising people who are not professionals, who are not managers themselves. This is not going to be a good L1A managerial application. They also have to have the authority to hire and fire and recommend personnel actions such as, leave, promotions, things like that. They also have to exercise discretion over day-to-day operations. One thing is that if you are a manager, but you don't manage that many people, maybe you have some indirect reports, but you are in charge of a function of the company, which is something that is critical or essential, to how the company operates, like the finance function or something like that, then you can potentially come over as a function manager. or your job can be, classified as a function manager, but you do have to show that you are managing the function, not performing it. So there usually does have to be some type of support, whether it's indirect reports, other people in the organization that are kind of, helping, kind of produce the work for that function. And you can argue that you yourself, manage the function, even if you are not directly responsible for managing anybody in that department. All right, let's talk about specialized knowledge. So this is for an L-1B visa, and specialized knowledge is defined as an individual who has special knowledge of the organization's product, services, research, equipment, techniques, management, or advanced level of knowledge or expertise in the organization's processes and procedures. So generally, you also have to show that this knowledge is not commonly held throughout the industry. So these are kind of many different things that you have to prove for this type of case. It can be quite complex. Advanced knowledge is often used maybe where somebody has been with the company a very long time. Maybe they're the one that developed these particular processes and procedures, or they're the one who's kind of taken that to the next level. Oftentimes that can be a very successful L-1B argument, particularly maybe if the person is earlier in their career, but if they have that special knowledge about the company because they were there at the formation, that could be one approach you can take, for an L-1B. All right, let's talk a little bit about the documents you have to submit for an L-1 petition. So one is you have to submit forms to U.S. Citizenship and Immigration Services. This is called Form I-129. You can also submit a form called I-907 to ask for premium processing to get an answer within 15 business days, which can be an approval, denial, or request for evidence. Um, you also have to submit corporate documents showing the qualifying relationships between the companies, proof that each company is doing business. So this can include things like company tax returns, audited financial statements, lease agreements, invoices, payroll summaries. If it's a very well-known company, you can submit some publicly facing information about the company. You also have to submit proof that the employee has worked for the company for that continuous year out of the past 3 years, and proof that they worked in a managerial, executive, or specialized knowledge role. This is where, they'll want to see things like a detailed job description, organizational chart showing the hierarchy, possibly work product as well, supporting what's in the letters. And then you do the same for the role in the US. So proof that the employee's role in the US will qualify as managerial, executive, or specialized knowledge. You're going to submit very similar information. And as I mentioned previously, the jobs do not have to be the same, but if it is a different job, or let's say someone was a specialized knowledge worker and now they're coming over to be a manager, you do have to prove that the person has the skills and abilities to hold the job in the US. So if it's a promotion, or if the person has developed these skill sets and they're going to bring those skills to the US, you want to make that clear in the application. What do you need for a request for evidence? So requests for evidence are quite common for L-1 petitions. They have dropped over the past few years, but we expect they may, return to kind of higher percentages of RFEs being issued. From 2019 to 2021, RFE rates were over 50% for L-1s. Data in recent years shows this has dropped, to the 30s from the 50s, but still, a relatively high percentage. Most of the RFEs are challenging whether the application is proving that the employee really held a managerial, executive, or specialized knowledge role abroad and will hold one in the United States. As I mentioned previously, they take a very rigid view of the regulations. And so you do really need to take that into account when you're designing the job description and kind of describing what the person does. They often will push back if they feel that, a manager is actually kind of writing the reports themselves, as opposed to having somebody else, write those reports and then they oversee it. So you do want to be thoughtful about how you're describing things, especially in smaller companies where people tend to wear multiple hats. Um, Always a very good idea with requests for evidence to supplement with objective evidence. So you're submitting letters, from, officials at the company. You're submitting organizational charts explaining how things work. And it's a good idea to supplement that with things like internal memos that were previously drafted, even email exchanges. If there's kind of software that shows a manager, approving, leave or promotions or writing reviews for people, all of those types of things are very helpful to support what is in the letters and to show, yes, we are, claiming that this person does this work and we have work product that shows that they are doing this work. All right, in terms of timing and process and dependence, for the L1 process, first the petition has to be approved by U.S. Citizenship and Immigration Services. Processing times can be several months, but you can pay this additional fee to get an answer within 15 business days. Approval, denial, request for evidence, or notice of intent to deny. If it's a request for evidence or a notice of intent to deny, you're going to submit a response, and then they will issue usually a final decision within 15 business days. Very rarely, they might issue a second RFE. It's possible. I've seen it happen a couple times, but most of the time you're going to get an answer, after you submit that additional evidence. After the L1 petition is approved by USCIS, then the applicant, if they're outside the US, they can schedule an appointment at a US consulate to get an L1 visa stamp. Um, if they're already in the US in a valid non-immigrant status, like let's say they came on a B1 business visitor, they can change their status to L1. And then spouses and unmarried children under 21 can accompany on L2 dependent visas. So let's say you're going to a consulate, your spouse is just going to apply at the consulate with you. You'll bring their passport, a marriage certificate as proof of the relationship, birth certificates for children, and they can get their stamps at the same time as the L1 employee. The spouse can work in the United States. They have unrestricted work authorization to work anywhere, including self-employment, and children can attend school, but they cannot work. Lots of questions that we receive are related to whether an L1 visa leads to a green card. And so for any temporary visa in the US, there's no kind of automatic process whereby you, become eligible for a green card. That being said, there are some common green cards that people on L1s will pursue, and we've discussed them here. So for an L1A, so somebody who was abroad as a manager or executive and was transferred to the US to be a manager or executive, they could apply for an EB1C multinational manager or executive green card. The requirements on their face are very similar to the L1A requirements, but there is a heightened standard that's applied here. So just because you receive an L1A approval, especially maybe if it was a very difficult L1A approval, you may not want to go directly to an EB1C. You may want to build up the operation a bit more because of the fact that there is this heightened standard because the L1 is a temporary visa and the EB1C is a green card that permits you to live and work in the US permanently. So you can see here, in terms of the basic requirements for an EB1C, there has to be that same qualifying relationship. Both companies have to be doing business. And for the EB1C, the US business does have to have been operating for at least a year. So if you come over on an L1A to open a new office, you cannot immediately apply for an EB1C. The company has to actually be operating for at least a year before you apply. The employee has to have worked in an executive or managerial role for at least, one continuous year prior to entering the US. So somebody who is a specialized knowledge worker maybe and then transferred as an L1A to become a manager, they're not going to be able to use the EB1C category because they were not an executive or a manager abroad. They were a specialized knowledge worker abroad. So that is, something to keep in mind. A benefit of the EB1C is there's no labor certification required, so you don't have to go through the perm process where you have to test the US labor market to see if there's any, willing, qualified, and available US workers. You can skip that. You file the I-140 with the proof, that you meet all the requirements listed here. And if you're approved and then your priority date is current, then you can go ahead and apply for your green card. Another benefit of the EB1C category is that EB1 is one of the green card categories that is not backlogged worldwide. It is backlogged for people born in certain countries, but worldwide it is still current and one of the few employment-based green card categories that is. So that can make it a very attractive category as well. If you are in the US on an L1B as a specialized knowledge worker, or you are a specialized knowledge worker abroad, so the EB1C is not available to you, another green card process you could consider is the PERM process. So this is where the company does have to test the US labor market to determine if there's any willing, qualified, and available US workers. It's a 60-day process where they're testing the labor market. They also have to get a prevailing wage determination from the Department of Labor, which is taking, 8 to 9 months. Then they file the perm with the Department of Labor. They're taking about 15 months to review those. If it's approved, then you can move on and file Form I-140. The company has to prove they have the ability to pay the prevailing wage. The employee has to prove they have the requirements, to do the job. And then once the priority date is current, you can go ahead and file, for the green card under the EB2 or EB3 employment-based green card categories. Generally, it is a much longer process than the EB1C. So if the EB1C is a possibility, that's generally a better option. But the perm process is there when it's, not an option. All right, so we've come to the end of the presentation. I don't believe we've had any questions come in. So I will close here. Thank you very much. I hope everyone has a wonderful day.